Mr. Ngwato, now the time is 9:38. We were supposed to start at 9:30. We were all here at 9:30 except you. What went wrong or what happened?
Morning, Commissioners.
Yeah.
Commissioner, I profusely apologize for the 8 minutes delay in time on our side. Unfortunately, I had to start at the higher court, but I have communicated the fact that we are at the higher court so that we can have the necessary documentation being stamped and accepted by the higher court. And for that, with traffic and accreditation just to come in, that delayed us with that 8 minutes. I profusely apologize. That is not in any way manner to disrespect the Commission.
You said something about communicating. What did you say? I think you said communicated. Or did I mishear?
Sorry, Commissioner, I didn't get that clear.
I thought somewhere in what you were saying, you said something about having communicated. Did I mishear?
Yes. Since at about 7 o'clock this morning, I've been in communication with the attorneys of the Commission, also in terms of exchange of documentation, where they were not having received necessary documentation.
Did that have anything to do with the possibility of you being late?
Yes, my colleague did communicate. He's just outside, but I will give you that. I can be able to give the details in terms of who exactly should communicate that we're running slightly late, or we might.
But in any event, Mr. Ngwato, you knew that you had to be here at 9:30. I do not understand why you would have had to go to the High Court personally. Surely you have other people in your law firm who could do that. And that's a very simple, attending to court and making sure that the matter is properly registered, assigned a case number and all that. That's a very minor, yes important, but very minor administrative issue, which could be done by anybody. It could even be done by administrative people who are not legally trained. Why it should take the owner of the firm, I assume you are the owner of your law firm, to go there and attend to this, it just does not make sense at all to me. For you to then make us wait for you, for something that could be done by someone else. For example, last week, you were there with Mr. Please remind me. Mr. Malika. You were there with Mr. Malika. Why could Mr. Malika not attend to that? Or whoever else for that matter. This is totally unacceptable. Totally unacceptable. It's actually unprofessional conduct to make us wait. Why did you not communicate with Mr. Shaskalsen?
Mr. Commissioner, like I indicated, that I've been in contact with the attorneys.
Why did you not communicate with Mr. Shaskalsen?
I don't have Mr. Shaskalsen's direct number.
You were communicating with the Commission's attorneys. You could easily have gotten his number from them. That's not an excuse.
Commissioner, maybe if I'm given a chance to respond, then the Commissioner will
appreciate. Yes, go ahead, please. Go ahead.
Thank you. As of yesterday, Commissioner, I have 6 times called DM attorneys, and I spoke to Mr. Mbao to give me the number of Geraldine Berger, who I know and have been introduced since the beginning of this proceedings to be the person, to be the contact person. For the entire day, I was not given those numbers. This morning, I spoke to the main director of DM attorneys himself, and I indicated my disappointment that their law firm, since yesterday, I've been communicating with one of the officials just to get through to Geraldine Berger, and I could not get those details. I was quite very happy when I now deal with the main director, and we started exchanging since this morning. We're traveling with one car. When we were just about to arrive, and I was requested to have a copy of the High Court, I indicated to Mr. Mokhasho that for some reason since this morning, my phone cannot open PDF documents. So I'm waiting for Mr. Malika to come outside court. I'm standing outside court so that I can send the necessary documentation to him. Unfortunately, in this particular instance, there was never any malice or any intention on our side to disrespect the Commission. I've been up since 6 o'clock this morning dealing with this particular matter. We left our office 2 o'clock this morning.
Mr. Ngwato, I will say this, and I do not want us to engage any further on it. What you say from where I'm sitting are excuses that are totally unacceptable. I maintain what I said earlier, which is that knowing that you had to be here at 9:30, there was no reason for you to attend to a minor, yes, important administrative issue that could have been attended to by anybody. Totally unacceptable. The discussion is closed.
But we appreciate the apologies for that, Commissioner.
Sorry?
We apologize for that.
Thank you.
Thank you.
Yes, Mr. Shaskalsin?
Chair, Mr. Ngwato was going to move a postponement application.
Yes. Mr. Ngwato, we have before us your postponement application. Can you proceed to move it, please?
Indeed. Commissioner, I must appreciate and thank the Commission for having granted us the postponement last week. And indeed, we definitely used off the time to the best of our ability as was granted since last week. However, since we started finalizing the documentation, certain things really cropped up and showed and changed the direction that we were taking, which therefore since necessitated this application. As it's commonly known, we are the creatures of instruction. It's our client instruction then to bring an urgent application in the Higher Court, purely and solely for two reasons. As the Commission is in possession of the papers, I take that the papers might have been read and apologize that they've been submitted to the Commission almost on the 11th hour. The first reason, Commission, is the same reason, one of the reasons that we mentioned last week, that the applicant, before he could even make his first written submission to the Commission on the 17th of December, an interim report was already been issued, which we fully understand and correctly so in terms of section 10.4 of the terms of reference, that the Commission is entitled to do so. But 2 days before he could even make his first written submission, an interim report has already been issued, which had recommendations and findings and recommendations against him. Unbeknown, and obviously we do not have access to that particular interim report, but just a day before our appearance on the 30th of January, which is last week, Friday, the state president publicly announced that he accepted the same report, and therefore an announcement was made that he needs to be charged. It is on the basis, that's the first reason, it's on the basis of that is of the view that even though at the Commission he is a witness, not an accused, but whatever he may be able to say as a witness at the Commission he may incriminate himself, which will be a violation in terms of section 35(3) of the Constitution. The second aspect that made us to then make the application to the High Court, Commissioner, is that in perusing the WhatsApp charts, the nature of the WhatsApp charts and the manner in which they've been extrapolated, it only shows outgoing and incoming. Even messages that were not originated by him, but he received them when they were forwarded to him, appears to be that he's the originator of the messages, which now distort the narrative and the version and how things are in terms of those messages. And as a result, that will then necessitate that he now gains access. That will now necessitate that we look into how the messages were extrapolated in terms of, from his phone, in terms of from the time it was...
Feel free to either put it on silent or switch it off. Don't feel any pressure not to do that.
Mr. Commissioner, it's not even my phone, it's Mr. Maleka's phone, and I don't know his password or his pattern, how to close it off.
No,
so mine is here, and this is Mr. Maleka's phone. Is Mr. Maleka's phone ringing?
All right, thank you.
So in the manner in which how this, the chain of evidence, or the chain from the time his phone was taken.
Is that Mr. Maleka? Please go across. Sorry.
Yeah.
Are you no longer comfortable to support your post the way you did last week, Mr. Maleka? All right. Please continue. I'm sorry about the interruption, Mr.
Thanks, Commissioner.
Yes.
So the manner in which the charts were downloaded or extrapolated from his phone leaves much to be desired, which appears to be a violation in terms of how the evidence is being presented, because it doesn't show the messages that are forwarded. It doesn't show that he received it as being forwarded to him, but it shows as if he's now the originator. And some key people or chats that he had with other people are not included in that. And I quite understand that the evidence leader said there were certain messages that are not of interest. But for a consistency basis, in particular, he's been much more in communication with one particular general and as opposed to the other. But and the things that they were discussing with the other are not included. That shows a wrong narrative or misplaced the whole view of the situation. And as a result, it was my clients obtained a legal opinion from 2 SC senior counsels, who then are the ones that are currently working on the application in the High Court, with a junior counsel based in Durban. These had to have took place as a matter of one day, having to go through this thing. And it is on that basis that if he is to come before this commission, whatever he says may not change because of, before he could make the first statement, an interim report was made. Before he could even appear, the president has already accepted that. So whatever he comes here and says may not change the narrative. And more likely that he will incriminate himself in any answer that he gives. And it's on that basis that that the applicant decided to launch an application in the High Court to restrict this commission, not to compel him to appear and not to compel him to answer any questions until pending the finalization of that application in the High Court. Thank you, Mr. Commissioner.
Thank you, Mr. Ngwato. Mr. Ngwato, I read, because I received the application only this morning, I read it hurriedly and I may have either missed or misread what I'm about to raise. I don't remember in the affidavit a point being made about WhatsApp chats that appeared to have been initiated by the witness when in fact they were not. Did I miss that? Or is this something you are stating for the first time from the bar, as it were?
Commissioner, I was just trying to elaborate on the reasons that I given. Because the first ground of him wanting the High Court to interdict is that his WhatsApp chat should not be displayed because those WhatsApp chats are not correct. They are incorrect in the manner in which they have come from, because the entire bundle of documents, they only show outgoing and ingoing. Even the WhatsApps that somebody forwarded to him, and he sent it to somebody, it only shows that he's the one sending and making him the originator, while he's in actual fact not the originator of the message. Okay.
With the exception of what you are raising from the bar, my reading of the application is that the only new thing that's being raised in the application affidavit is the issue relating to Section 35 of the Constitution. The rest is something that the applicant ought to have raised in his postponement application moved last week. Do you agree with me?
May you please repeat?
I'm saying I read the application, today's application, to raise only one new issue, leaving aside the point that you are making from the bar. And that one new issue is the issue relating to Section 35 of the Constitution, the right to a fair trial in the context of a criminal trial. That's the only new thing that I saw in my reading of the application. The rest are issues that the applicant ought to have raised in his postponement application that was moved last week. What's your comment on that?
If I understand you, Commissioner, is that the things that are mentioned in the current application, is the Commissioner saying most of them are the things that were raised in the previous application?
It are the sort of things that could and ought to have been raised in last week's application. The exception is the Section 35 issue. That, on my reading, is the only new issue.
I differ, Commissioner, and maybe let me explain myself in terms of maybe try to find out common ground between the two. When we moved the application last week, it was simply because that we had not had time to peruse. Now, the time to peruse obviously goes hand in hand in the manner in which we received the documentation. But on further perusal of the matter, these things now become very clear. That Section 35, subsection 3 rights will be highly affected. But it all emanates also in terms of how he has been served right from the beginning. So there's a lot that starts and giving context from the beginning of how he received the notices and the ultimate aspect, if I'm making myself clear.
Yes, Mr. Ngwato.
And maybe just to conclude, Commissioner, we obviously gave the client a legal advice in light of the Zuma case, and I'm quite aware that the Commissioner is quite vested with that case, if not that participate in that case. And we had to distinguish between the rights of an accused as opposed to the rights of a witness. Because you could not invoke the right to remain silent because he's not an accused in here, he's actually a witness. But as a witness that is already being charged, is more likely to incriminate himself, which now prejudices his rights. And hence the focus in terms of that is the Section 35, subsection 3 rights that could be violated.
Thank you, Mr. Ngwato.
Thank you.
Thank you. Mr. Shaskalson?
Thank you, Chair. Chair, this application needs to be seen in the light of the chronology. The witness has known he has to give oral evidence at this commission since sometime in November last year. He knew about the date of 30 January more than 2 weeks ago. He was provided with all of the WhatsApps that have been made available to the commission on 22 January. That was 12 days ago. He has no basis from preventing the Commission from having regard to those chats and from confronting him with those chats. But if he wanted to do so, if he wanted to bring some application in that regard, the time to launch that application was 12 days ago. He chose not to. Instead, he delayed until 28 January, that was 2 days before his hearing date, and sought a postponement of hearing so that he and his attorney could work through the WhatsApps. He brought his postponement application on 30 January. It was moved on 30 January. By that time, he knew about the recommendation in the interim report, but he elected not to address it in his postponement application. He successfully derailed the hearing set down for 30 January and was given a postponement to today. Then this morning, he brings a new postponement application. This one is linked to a High Court urgent interdict application that he's apparently now served, and that in draft form was attached to the postponement application. According to the draft notice of motion, the High Court application is to be heard on 10 February. That's in a week's time, so it would derail any prospect of him testifying this week. The relief sought in the High Court application is framed in a confusing fashion. Prayer 1 is relatively simple, it's the urgency prayer. Prayer 2 is a prayer for an interim interdict restraining the Commission from compelling the applicant to appear before the Commission until, quote, finalization of this matter. Prayer 3 is a prayer for an interim interdict restraining the Commission from exhibiting the applicant's WhatsApps pending, quote, finalization of this matter. So 2 and 3 seem to be prayers for interim relief. And what are they contingent on? They're contingent on prayer 4, which is the prayer for final relief. And that's a prayer for an order reviewing and setting aside the notice in terms of Regulation 10.6 and the summons directing the applicant to appear on 30 January. So they want those two documents or instruments set aside. And they want them set aside because they were issued, quote, whilst having issued an interim report to the President with findings and recommendations against the applicant on 15 December, and which the President implemented on 29 January, which is contrary to the rules of evidence and principles of fairness. So it seems to be this new fair trial complaint. And that's the final relief. Now, the urgent is a complete abusive process. If it was going to be brought at all, it should have been brought long ago, and certainly before last week's postponement application. But in particular, the prayer for interim relief preventing the Commission from exhibiting the witnesses' WhatsApps is utterly hopeless, because it is completely unrelated to the prayer for final relief. Even if the witness were to obtain the final relief in prayer 4, there is nothing that would prevent the Commission from exhibiting his WhatsApps. The ordinary rules of evidence in courts don't apply to a Commission. Rule 6.1 expressly states the Commission may receive any evidence that is relevant to its mandate, including evidence that might otherwise be inadmissible in a court of law. These WhatsApps are extremely relevant to the mandate of the Commission. In my view, they are more relevant than any evidence that has ever come before this Commission thus far. So whether or not the witness ever gives oral evidence at the Commission is entitled to have regard to the WhatsApps. And in view of their extraordinary relevance, it's not just a matter of being entitled to have regard to them. The Commission is obliged to have regard to them. Having said all of that, there is another issue, which is the fair trial complaint that is advanced now is itself stillborn for two reasons. The first is the regulations and the Commissions Act make clear that the witness has a right of privilege against self-incrimination in these proceedings. So the witness can refuse to answer any question that is potentially self-incriminatory. The second is that any evidence that the witness gives in these commissions is inadmissible in a criminal trial. So the fair trial complaint is a non-starter. But despite all of that, and despite the fact that this application and the postponement application are, in our view, abuses of process, we are willing to accommodate the applicant to a limited degree. What we propose is that we will not ask the applicant to answer any questions until his High Court application is finalized. However, we will not refrain from exhibiting his WhatsApps. Rather, we will use today and the remaining days that we would have used to hear the evidence of the witness, instead to display his WhatsApps and to explain their significance. If at the end of that process and after the High Court application, the applicant wants to give evidence to refute any of the inferences that we will in the course of the next few days ask the Commission to draw from the WhatsApps, he's welcome to do so. We undertake that if he wants to come back and testify to clarify any wrong propositions that we have put to the Commission, wrong inferences that we've drawn, we will ensure that he has that opportunity. There's another issue that I should just mention, which is that he has never previously expressed any concern about not being told which of the chats are forwarded and which of them originate from him or from the counterparty. If he had, we would have given him a spreadsheet for each set of chats which says which are the forwarded chats, which are the originating chats. He now raises that complaint. If he wants that information, we're happy to give it to him before he decides whether or not to come back to testify. But what we're not happy to do is to allow the process of this Commission to be derailed again. So our submission is that this postponement application should be dismissed, subject to the condition that we will not expect the applicant to answer any questions in respect of the WhatsApps that we will be displaying today, tomorrow, and possibly later this week. Those are our submissions, Chair.
Thank you, Mr. Chaskelson.
Mr. Chaskelson, can I just to clarify, I mean, if a postponement is refused, the witness is not excused. He has to remain in attendance, otherwise we are confusing. We refuse a postponement and then we excuse him. If it's refused, it seems to me that he would have to remain in attendance until he's excused by the chairperson. But if he remains in attendance, sitting, which I think he must, sitting in the witness box, it's entirely up to him how he wants to participate. Yes, he will be sitting remotely as was permitted with the last application. But as long as he remains in attendance, you will do the exercise, you will do your presentation as you wish to do, and it is really up to him how he chooses to participate. Because if he should decide, as he's sitting there, that he does want to engage with what you are presenting, we obviously can't stop him. But I just want I want to be clear about that a refusal of a postponement, it doesn't follow that he gets excused. He's given leave to leave the commission. It means he remains in the commission until the chairperson says otherwise. And you're not suggesting that if that happens, if he remains in attendance, you will simply present he shouldn't participate in the process. You're not saying that.
No. If he is entitled to participate as much or as little as he wants to.
Thank you.
Mr. Mwato, if you have any reply, but there are two specific issues that I would like you to respond to. First, the point made by Mr. Shaskalsin that the Section 35 point is still born for the reasons that Mr. Shaskalsin gave. I'm sure you remember them. And then, secondly, the exhibition of the chats and commentary on them, which is how Mr. Shaskalsin proposes to proceed today. So your comment on both those and whatever other reply you may wish to make, please.
Thanks, Commissioners. Commissioners, there were 4 aspects that I wanted to respond to based on the statement by Mr. Shaskalsin, and 2 of them actually emanate from the same aspect. The first one is that he says he's been aware of this when he was invited, and if he wanted to bring about an urgent application, he could have done so, even including last week. And just to clarify that particular aspect, the applicant could not in any event, in anyhow, could have been aware and could have therefore acted therefore. When the interim report was issued on the 15th of December, before he could even submit his first statement, he was not aware of the interim report. And the interim report is a confidential document that goes to the president. Nobody has an access to it. So he could not in any way been aware of the recommendations and findings in the interim report. Second to that is that even last week itself, I indicated in the last postponement application that just in the midst of preparation on the 29th, a day before, that's when the president made an announcement. And in that announcement, his name for the first time appeared. It is the only first time ever that he became aware. That was a night before he could appear in the commission. And second to that, or to support that, when we appeared on the commission on the 30th, we said, we have received this 4,800, now reduced to 1,300, but we have not yet finalized studying the documentation. So he could not have at that time appreciated what his rights and what his rights are, because he had not even gone through the documentation. So it is incorrect to then suggest that had he wanted to bring this thing, the matter he would have done so, and therefore there is no agency in the matter. And that's the part that will be argued in the High Court in terms of when did whether the matter is urgent or not. That's the first comment with regards to the comments about agency and when he became aware of that. The second aspect will also go together with the Section 35, subsection 3, in terms of the right to a fair trial. Is that now that he has have gone through the WhatsApp chats and now appreciate the veracity and the implications brought by these WhatsApp chats that he has now finalized yesterday, it became quite very clear that whatever answer, especially in light of this recommendation has been accepted, whatever questions they pose or whatever WhatsApp they display will implicate him in the next criminal proceedings that have already been approved by the state president, whether it's criminal proceedings or internal. So it greatly then affects the right to a fair trial in terms of him being able to, him possibly implicating himself. But also, I indicated that these WhatsApp chats, in the manner in which they've been extrapolated, which now the evidence says if there's a need for that, they could provide. They've been extrapolated or in an incorrect manner. And I gave an example of a WhatsApp that has been forwarded to him is now being portrayed as he is the originator of that WhatsApp. So even if you display them here, it will be misleading the country because it's going to be seen as he was the originator of that WhatsApp, whilst in actual fact he's not. And as a result of that, it then brought about in terms of whether the authenticity of this WhatsApp messages. Because how was the phone taken? What are the qualifications of the person who downloaded the WhatsApps? How truthful are these WhatsApp charts? Because in so doing again, will be a violation of his rights because we already identified quite a great number of them that they were not originating from him, but they are now being displayed as they originate from him. Now, with that being said, is that this commission will then be failing its own mandate, because the mandate of the commission is that in terms of the terms of reference to their allegations, assess the information, and then make a determination if there's a prima facie evidence against a particular person. In this particular instance, decisions already been made, recommendations have been made, but more importantly and central to that is how these WhatsApp chats have been obtained from his phone. It must also be remembered, Commissioner, when you received the first notice, it was not about WhatsApp chats from his phone. It was WhatsApp chats from somebody's phone. That's the one when he received the first notice and the summons. The only time he now receives WhatsApp chats from his own phone, and the evidence leaders testified about that, how they struggled to get the information from SAPS. They only got it last week, and therefore they were able to work it out. It was just last week. And therefore, he could not have appreciated the nature of the WhatsApp chats any time before. He could not have appreciated the fact that he could bring an urgent application any time before until the state president makes an announcement on Thursday last week, and he was to appear the next day. And to respond to the two aspects that you said, I must maybe have a look at it. That in terms of Section 35, is the right to self-incrimination. Is that those WhatsApp charts are just the same as any oral evidence or any type of evidence. They are incriminating, especially if the source of how it has been extrapolated is highly questionable, which now portrays him to be the sender, whereas in actual fact he's not the sender. He's actually forwarding what was sent to him. He's not the originator of the message. And in terms of the terms of reference of this commission, one is that the commission need to look in terms of how criminal or drug cartels have infiltrated SAPS. And if there is a message coming from a person that perceived to be part of the cartel and sent to him or forwarded to him, and now he forwards to somebody else, and now he looks as if he's the originator of that, that makes him to be participating or having facilitated in the organized crime. So there are far much reaching implications, and hence the application to the High Court is to forbid and restrain this commission from using those WhatsApp charts pending the finalization of the High Court application. Thank you, Commissioner.
Mr. Ngwatu, you've heard, and I assume that you know that to be a position of law, but you've heard Mr. Chaskalson say that anything that this witness says in this commission may not be used in criminal proceedings. So when you speak about self-incrimination, that is handled by the Commissions Act, which says, and the established law, that any evidence he gives here may not be used against him except for perjury, if he perjures himself there. So I expect that then that's not an issue. That's not a ground to avoid him testifying. That's one. Two, you make an assumption without a basis of what will be required or required of the witness to answer in any processes that the President has announced must follow, arising from what we have referred to, that there's prima facie evidence. And in fact, there's no basis to refuse to testify when you don't know, when he doesn't know how that process is going to unfold and what he will be required and expected to answer and speak to. So from where I'm sitting, your concern about self-incrimination, whether in court or in SEP's processes, doesn't seem to be grounded in law or in any known facts. And that in my view, should dispense with any concerns about self-incrimination. Two, you seem to, you're concerned, firstly, the witness seems to want to know in advance what he will be asked before it is put to him. That's how I understand the complaints, the grounds on which you're seeking this postponement from what has been said in the papers that you have filed with us here. That he wants to know what he's going to be asked because the language he uses is, I'm going to be asked questions in an open-ended fashion and I don't know where it will go. And that's a repeat of a theme of last week when you applied for the postponement. It was pretty much the theme. He doesn't know what he's going to be asked and it could go anywhere. But that's true for every witness. That could never be a ground, in my view, for any witness to be excused from testifying. So that's two, and you can say why I haven't heard why you say that's a ground for a witness to refuse to testify. And lastly, the issues you referred to about it's WhatsApp messages from other people forwarded to him. He doesn't know who downloaded them, the integrity, and he doesn't know the integrity of that process. But that's matters that witnesses get to speak to when they're in the witness stand. And I want also to note that there are two, from what you've said, there are two tranches of documents. There's the first batch of documents that he got previously, and my understanding on Friday of you was that he has no difficulty testifying to that. So it's not a blanket concern. Last week you said to us he has no difficulty. In fact, I remember saying to you, so we could proceed today on that first batch of documents and you wouldn't have caused a postponement, and you said yes. So your complaint doesn't relate to that, so you should be perfectly able to speak to that first batch of documents. The second batch is the 4,500 pages. Again, I'm going to repeat myself that what you're raising as matters of concern are matters that many witnesses have to confront on the witness stand, and they say, but this is not from me, it was forwarded to me, it's not mine. Those are answers that your witness should be able to give, and I don't see why that would preclude, why he would be precluded from saying that. It has not been suggested that he wouldn't be entitled to do that. But importantly, it's not grounds to refuse to testify. Thank you, Chair.
Thank you, Commissioner. I think, Madam Commissioner, you raised 4 points that I have to address and respond to. The first part being, we're making an assumption without a base that he might incriminate himself. I wish to submit with the greatest respect that the basis in which we're moving from, Madam Commissioner, and if I were to combine this aspect together with the last aspect that you mentioned in terms of the first part of the documentation. And when we approached the Commission the first time last week Friday, we clearly stated that the first part of the WhatsApp chats he received, they were not WhatsApp chats from his phone, but he was asked to make comments about it. And he had no problem in doing so, and then he has since submitted to the Commission. The challenge and the problem to compound the problem was that when we now received the WhatsApp chats from him, we're given short space of time. But secondly, or on top of that, was the pronouncement by the president. Now, when the commission now states that there is no basis for him to incriminate himself, is that the president has already made an announcement that he must be charged. It is a matter of administrative process that at any given time from now onwards he could be charged. And it is true, he does not know what is going to be asked about. And if it's even worse with that he does not even know what is going to be asked about, that he could be saying things with the hope of clarifying and assisting the commission whilst digging a grave for himself. And that becomes a dark room to walk into and navigate, because you're now walking into this dark room that you don't know. It even makes it even worse. But when we approached the commission last week, we never at any given point asked to be given questions. We stated that yes, he was never given questions, but we never make any demand of being given questions. Now, that becomes a problem when you now finally receive the documents and you finally study the documents. And you find that the documents that has been given to you, and I don't want to suggest that this evidence that has now been given to you is being tempered to suit a particular narrative. But it then comes out clear that messages that were not sent by him are now being made to appear that they were sent by him. Because the contents, if you are to be asked about the contents of that particular message, which now shows you're the originator of that message, whatever answer you give, you are acknowledging and accepting the contents thereof. And that over and above the fact that the evidence from here may not be used against him at a particular instance, but there's beyond the right to self-incrimination that the person is entitled to. There's a right to dignity. This particular person is not just him, there's his family involved, and now a whole wrong, incorrect narrative will have been placed in the public domain, which not just affects him and his livelihood and his children and his wife. And hence he wants to the court to interdict the use of these charts in the manner in which they've been presented to him. Because in the manner in which they're presented to him is incorrect. And he can't answer any other thing in terms of those.
Thank you, Mr. Mann.
Thank you, Commissioner.
Can I good morning, just clarify two things. I'm looking at the president's statement here, and I want you to tell me where the president says this witness must be charged. Because you're attributing to the president and to this commission things that are not said anywhere, and you're using them as a basis for a postponement application and a high court application. I will read for you what the president said in his statement. The commission has said there's prima facie evidence of wrongdoing, and referrals are made in respect of these people. But you making an application on the basis that there's a criminal case and somebody has been charged. But there's no basis for that. Because wrongdoing could be HR related, could have nothing to do with criminal proceedings. So don't attribute to the president statements he did not make. That's the first point. The second point is, if your entire argument is taken to its logical conclusion, especially in relation to the privilege or the right against self-incrimination, it means your client will never testify in this commission, because even in 6 months' time, there will still be a concern about self-incrimination, which means he should never come here and he should never take part in this commission, and we should just forget about it, because that's the logical conclusion. Thank you, Mr. Watt.
Perhaps if I may just add to the first point that Commissioner Kumalo says, reading from the president's statement, the media statement, it actually also reads that a task team will be constituted. The task team will institute investigations against people identified by the Commission for investigation. So nowhere does it say your client is going to be charged and what he will be charged with. It just says a team is constituted to conduct investigations. So self-incrimination is not an issue that you can rely on at this point.
Thank you, Commissioners. I appreciate that. Let me start with the first one that Commissioner Kumalo indicated. Thank you. Thank you so much. That the statement by the President does not make any reference to any criminal case. It might as well be an HR case. But whilst we are quite very clear that in terms of the terms of reference of this commission, the commission is to make recommendations and findings for criminal charges and any other process. And that's in terms of the terms of reference of this commission. So I don't think any terms of reference from this commission can be taken less the criminal aspect as well. That's number one. Number two, even if the process may...
Mr. Ngwato, you're not answering me. You said in your submissions, the President said your client must be charged.
Commissioner, if
now, I was simply pointing out that nowhere in the President's statement does he say that, because the statement says the Commission has found prima facie evidence of wrongdoing and has made referrals for investigation, which is what Commissioner Baloy is emphasizing. Let's not play around with words. I mean, either you're answering what I'm saying and you address it specifically, or we don't deal with it at all. But to say you can imply other things that are not there, it's simply incorrect. You're making an application and you're saying one of the grounds upon which the application is brought is that the day he was supposed to testify, he found out that the President said he must be charged. Either that is correct or that is incorrect. And then we can deal with the issue of self-incrimination, which, as I said, on your argument, that will always be there, which means on your argument, he should never come to this commission and testify. So those are the 2 points. Please deal with them specifically, but let's not go around them.
Commissioner, unfortunately, sometimes there is no just a simple way just to give you a yes or no to an answer. You have to give a context to it. And giving a context to it is not avoiding answering your question, but it's just trying to clarify the issue. But what I'm trying to say to you, Commissioner, is no tax team, no investigation will not lead to a person being charged. The tax team at the end of the day, the investigation at the end of the day, because there's a prima facie evidence of wrongdoing. Wrongdoing in this instance has not been explained whether it's wrongdoing only in terms of HR-related matters or in criminal matters. So whatever way that he's going to answer, there is already a prima facie wrongdoing before he could make a written submission or could say anything. And that in itself, Honorable Commissioner, is a ground for one to implicate.
Isn't that the problem? You don't know what wrongdoing has been identified. You have absolutely no idea. Absolutely not. Maybe the wrongdoing is that he exceeded the speed limit on Rivonia Road. You have absolutely no facts to base yourself on to say whatever he's going to be saying about these WhatsApp messages in the 4,500 pages will be self-incriminating. You have absolutely no basis. You haven't seen the report. You don't know what that report says about your client or this witness. You have absolutely no idea. And so you have no basis whatsoever to say anything at all that he's going to be saying here is self-incrimination. As I say, and I say it without meaning to be flippant, but to make the point that it could be that the wrongdoing that causes the President to order an investigation against him is he exceeded the speed limit. You don't know. You have no basis. This is really, honestly, a fact devoid application. You may want to argue the legal points that you rely on, but where you want to say, well, he's going to incriminate himself, well, the WhatsApp messages, there are no facts. We don't know what those WhatsApp messages, what his explanations are for them. We don't know, and yet you want to rely on that to persuade us, the commissioners, to grant a postponement, when you are not saying to us, here are the facts about those WhatsApp messages, here's what they speak to. And so you commissioners should not allow them to be showed. I mean, that's what you do with an application. You're asking for indulgence from us. There's no order of court that says we can't proceed. So as matters stand, we are entitled to proceed. You seek an indulgence. You haven't, in this application, pleaded any facts on which we would base our indulgence, at least according to me. And I don't know that there's any, and of course subject to the chairperson, I don't know that there's
facts or law.
Facts or law, absolutely. I really don't know that there's any, we're serving any real purpose with this continued exchange. You have made your case on your papers, you've been engaged by us. You're not saying anything new to us. You keep repeating what you have said. I'm not sure where we're going with it.
Chair, with the permission of Chair.
Yes, Mr. Ngwato.
Thank you, Chair. Chair, I really don't want to appear not listening and taking the cue from the Commission. But I really have a serious problem with the following issues that there is no basis. Chair, the Commission is based on the terms of reference. The terms of reference are quite very specific as to what the Commission need to inquire. It is not any other thing. And the specific issues that the Commission need to inquire is to establish the following issues. One, if there's any infiltration in...
Can you please, we all
Yes.
know what the terms of reference provide.
So when we look in terms of the answers is to give, it is not just any other thing, whether it's a speed limit or anything else. It is specifically in terms of the terms of reference of the Commission. We serve as the basis. If they say there's a prima facie evidence of wrongdoing, that is in terms of the terms of reference of the Commission, not nothing in anything else. And it is that, Madam Commissioner, that we have looked in terms of what the terms of reference of the Commission is. We have looked in terms of the WhatsApps. We have looked in terms of the process. We have looked in terms of the answer that they have to be able to provide. Is there any possibility of incrimination? Definitely there is. Whatever he's going to come here and say, he'll be incriminating himself. He'll be digging his own grave even deeper.
All of this arises from the point made by Commissioner Kumalo with regard to what you said about what the President said. Can you please wrap up your response to that simple issue, please? Let's not open up the debate because you've addressed the debate with regard to other issues.
Yes, finally and in short, Commissioner, is that yes, the confirmation by the President tied the horse that there is, he has accepted the recommendations and the findings of the Commission. Tax team must be set in terms of to investigate, which investigation will lead to the charges, because there's a prima facie evidence that's already been established. And on that basis, that serves as the ground for him to incriminate if he continues in that particular process. Whether is he going to ever come before the Commission? Yes. After the finalization of the High Court, if the ruling of the High Court is that there is no merit, then he has to come and proceed. It's not like he's avoiding to come before the Commission. It's known in this country, if you refuse to appear before the Commission, you'll find yourself in contempt and the implications thereof. So he will come and appear if the ruling of the High Court is otherwise. Thank you, Commissioner.
Thank you, Mr. Ngwato. We have read the papers in the postponement application. We have heard submissions on the application. We noticed that today's application is replete with a rehash of the issues that were raised in last week's postponement application. The only new issue really is the Section 35 point. The Section 35 point is answered simply by the response given by Mr. Shaskalsin and amplified or added to by Commissioner Baloyi. For the reasons given by Mr. Shaskalsin, that point is still born and therefore can never be a basis for a postponement of today's proceedings. Mr. Shaskalsin suggested a practical way of dealing with this to the extent that the witness may not be prepared to participate in today's proceedings. And that practical way is for the evidence leaders to exhibit the contested chats with what they see as necessary commentary on them. And Mr. Shaskalsin further says that if the witness is so minded, he may at a later stage come back to the commission and say, I now want to file an affidavit that responds to those issues. I now want to come to the commission and testify on those issues. That is, those issues being whatever arises from the chats that will have been exhibited and commented upon by the evidence leaders. That to me sounds like a sensible, practical way of dealing with the matter. That is, of course, if the witness insists or persists in his stance of not testifying today. But if we reach that stage, that is, of proceeding in the practical manner suggested by Mr. Shaskalsin, what we will not allow is for the witness to leave. We will not excuse the witness. The witness must remain in attendance, remotely of course. We will not excuse him. That is, if that is the stage we reach. Now, before we make a final pronouncement, Mr. Ngwato, may I ask for a response from you? And indeed, at this stage, perhaps I might even have to engage the witness himself. Mr. Ngwato, so is the position, because the inclination is that we should proceed along the lines suggested by Mr. Shaskalsin. So is the witness's position, through you as his representative, that he will not participate and that the evidence leaders should proceed in the manner in which they are minded to proceed? What is your response to that?
Honorable Commissioner, the witness has been made available. He's since been picked up at 6 o'clock this morning. He is available. He will sit in, but he will definitely not participate.
I'm very, my sincere apologies, Mr. Ngwato. Can you please start from the beginning? I'm sorry.
In short, Honorable Commissioner, the witness will not participate.
Will not participate.
Will not participate.
Thank you.
Because for the reasons already given, if the commission orders him just to sit in and be available, he will sit in and be available, but he will definitely not participate.
Thank you.
No comment.
Thank you. As I said, I think we would like to hear the witness directly as well on this, because it's a very crucial issue. I do see witness F on screen. Witness F, have you been following? Have you heard what I've just said?
Good morning, Commissioner. I've been following you.
Good morning, Witness F. Mr. Ngwato has just said that you will not be participating, but I want to hear it from you, whether you also confirm that you will not participate.
I confirm, Commissioner.
But as you probably also heard, we as the commission are not excusing you. We are not releasing you. You should continue being part of the proceedings remotely, even if you are not saying a word.
I confirm, Commissioner.
Witness E, but I will ask both Mr. Chaskalson and your attorney to respond. But what I must draw to your attention, we may have indicated an inclination as to the practical manner in which we want to deal with this. But we are just worried that what we are doing, which is informed by the practicalities arising from what was sprung on us this morning, may be seen to be creating a precedent for other witnesses. In terms of Section 6 of the Commissions Act, it is an offense for a witness to refuse to answer questions. So, to the extent that you say that you will not be participating, the entire context being that even if asked questions, you will not respond to them. That is an indication that you upfront are saying, I am going to commit an offense under the Commissions Act. Mr. Chaskalson, do you wish to address us on this? And Mr. Ngwato, will you please respond? You've heard that, Witness F, and I hope you understand its serious implications.
Sorry, Chair, I just want to repeat on record that we will not ask any questions of Witness F. So, I mean, obviously we can't speak for the commissioners, but we will not be asking any questions. So, flowing from us, that issue will not arise.
Thank you, Mr. Chaskalson. Mr. Ngwato?
Thanks, Commissioner. I think that's much a loaded statement. Then he has nothing to answer if there were no questions to ask to him.
Although you can never anticipate that we will not want to ask questions. Mr. Chaskalson's attitude is not necessarily ours. So the point about the potential commission of a criminal offense still stands, and that's what I want you to respond to.
Commissioner, I don't think much, and this is me maybe subject to having to consult with the client and explain this clearly. I don't think he'll be committing any of that offense in that one, he has presented himself, he's here. It is as a result of the discussion that and the ruling that has been made by the commission and the compromise that has been made by the evidence leaders that they've got nothing to ask him. That him being available and attending and not answering questions because there are no questions will be committing any particular offense. And if the commissioners may want to ask him a question, he may answer and say no comment. And still, that doesn't make him to not be responding to questions because he can as much simply to any other question, and I'm not trying to influence him not to answer any question. He may simply say no comment because I've not had a legal advice or I'm not happy with the manner in which things have been. He could simply say no comment, and that in itself does not make him to be committing any crime in terms of that particular section. Thanks, Commissioner.
Mr. Ngwato, you and the witness may well be advised to look at Section 6 of the Commissions Act. Nothing precludes us commissioners or any one of us to ask questions of this witness. Whatever Mr. Chaskalson may have decided, whatever approach he may have decided to adopt, nothing precludes us from doing that because we are the investigative body, the commissioners. And Section 6 says a witness who having been sworn, fails to answer fully and satisfactorily any question lawfully put to him. I want you to be mindful of that, whatever you advise the witness, as you're entitled to do, that whatever arrangement or whatever approach adopted by Mr. Chaskalson does not insulate him from questions from the commissioners, but it also doesn't insulate him from the legal obligation that arises from the Act to answer fully and satisfactorily questions that we lawfully put to him. I just wanted to point that out to you.
I appreciate it, Commissioner. Any answer given by the witness does not have to satisfy the commissioners. If no comment is equally what he wants to say, that is his answer.
I'm not opening a debate. You said something that I thought you seem to not be aware that his obligation is to answer fully and satisfactorily. Whether to say no comment is to answer fully and satisfactorily is a determination that we will have to make, is the simple point that I'm making to you. So I'm not asking you to comment, and I'm not inviting an engagement. I'm just pointing out that as you advise him, including if you are going to say to him, as you have suggested, he may choose to do, to say no comment, ultimately it's for us, the commissioners, to determine whether a no comment is to answer fully and satisfactorily questions that we have asked. That's a simple point I was making.
As the commission pleases.
Thank you. Thank you, Chair.
Chair, can I just clarify, is Mr. Maleka or another member of Mr. Mwato's firm present with witness F at the moment? Because there are issues under Section 3(4) of the Commissions Act, which gives witness F a privilege against self-incrimination if he's asked questions. And I just want to clarify that there will be legal advice available to him where he is.
Mr. Ngwato?
Thanks, Commissioner. Unfortunately not. We were all divided in terms of other team members have been at the High Court this morning, as I indicated, and Mr. Maleka is here with me. So the witness, unfortunately, is not with any legal representative from our law firm where he is right now. He is at the offices of the attorneys. Okay.
We didn't get that, Chair.
Why can't Mr. Maleka be with him?
Well, that would mean for us, for Mr. Maleka to be with him, we have to stand down. But preferably, the leading attorney on the matter, I would prefer that I'm the one that's supposed to be with him than Mr. Maleka. And that would mean that I have to travel to wherever he is.
No, if need be, we would rather have to call him or something. I prefer, and I think this is shared by my co-commissioners, I prefer that you should be here with us in case there is a need for engagement and interaction. I prefer that you should be here, not somewhere remotely.
On that basis, Commissioner, may I ask that we stand down so that I can make necessary arrangements?
We were going to anyway.
Okay, thank you so much.
We won't indicate for how long, we'll just indicate when we are ready. Let us adjourn.
The recording